Hey everyone, Coach Mary here at Totally Do You, and Totally Do You believe that justice is for all. The word says a single witness shall not appear in trial against a man for any wrong or sin he has committed. Only testimony or evidence of two or three witnesses shall charge a man. So today, talking again about due process, in this case specifically hearsay, which is when another person explains what a person said or did and there's no evidence of it or they can't prove it. In this case, we're talking about the other man that was there, Swish, or Mr. Brown, who apparently decided he wasn't going to testify, which I guess Miguel didn't have his right to face the accuser, who pointed him out from the police car. That was what Mr. Brown did, pointed out Miguel from the police car. So the public defender talks about what was the delay in calling the police, the marijuana on scene. Of course, she's quickly shot down by the prosecutor and the judge that she can't talk about that because it's hearsay to anything that Swish would have said about not calling the cops right away or anything that he would have done or weed that he would have had. So basically, even though there's this hearsay rule and the judge and the prosecutor are saying that you can't use the testimony saying what he said and what he did, here we see right there in the same witness's testimony, she then says what he did and what he said, and there's no hearsay there. So it is a little bit confusing, as the public defender says that the prosecutor can use the evidence and use the hearsay, what she said, even though what she said he said, even though she has a dishonest crime. But when it comes to the drugs that weren't collected or processed, that's not relevant. The jury doesn't have to know about that. And if she says they were the same size, he doesn't have to come testify, right? That's not part of due process, and everybody, the jury doesn't have to see that. So basically, the fact that she changed her testimony from her deposition to the jury testimony, making it look less like self-defense than she originally did. I guess the judge, Federico, who read the deposition and heard the jury testimony, didn't have a problem with that. I think that's because he thought here that in the very beginning of trial, some idiot kicked the door down and hit her with a vase. So I guess he already determined the guilt, which is pretty lucky for the prosecutor. And here's just a funny thing about how somebody's innocent until proven guilty. That's what Federico said. So totally do you believe we need more checks and balances in the lower tribunal court? Like, subscribe, and share your experience, please.